Call Kelvin Davis.
Thank you, Mr. Chair. And again, as a brand spanking new member on the Law and Order Select Committee, I wasn't aware of the genesis of extended supervision orders. So it's been very valuable for me to sit here and to listen to the Honourable Phil Goff talking about how in 2004 his concerns around the imminent release of offenders who he believed would probably go on and re-offend against or sexually against children and young people. So it's been really interesting to hear also his angst about that situation and how that's why the extended supervision orders were put in place in 2004, and they were to last for 10 years. And that 10 years now is about to expire. And it's interesting to note that even after 10 years of extended supervision, we still realise, we've come to the realisation that there are people who just will not get over their urge to re-offend, and therefore the need for this bill, the Extended Supervision Orders Amendment Bill, the Parole Extended Supervision Orders Amendment Bill, so that in effect extended supervision orders can be extended as often as needed. And I think it's really, really important and that we recognise that there are just some people, regardless of the amount of help, rehabilitation that they get in their time in prison during their sentence, that they will still come out of prison and re-offend. And the Honourable Phil Goff gave a sad example of that. The scope has been expanded, as others have mentioned, to include high-risk sex offenders against adults and very high-risk violent offenders. Mr. Chair, it would be remiss of me to stand and to talk about on a bill that involves sexual abuse and sexual offenders without reiterating to the country, to the House, just how prevalent sexual abuse and sexual offending is. And I'll raise the example of when I was a principal of a school up north, that in the space of 15 school days, in the space of 3 weeks, 13 instances of sexual abuse were brought to my attention. Now, they weren't all immediate. Some of them were historical, but I was having to deal with them as a principal. So it'd be remiss of me, Mr. Speaker, not to bring up the fact that sexual abuse is rampant, and this House must do everything in our power to stop it, to prevent people from recidivising, and this, the Extended Supervision Orders Amendment Bill is one of those instances where we're doing something proactive to protect boys, girls, men, women from sexual abuse. I just also want to raise another instance of a letter. A number of us may have received a letter from this man who's in Christchurch prison at the moment. He said, Calvin, he wrote a letter to me, he said, Calvin, I'm in prison because I did some bad stuff, but the bad stuff, the genesis was in the abuse the sexual abuse that I suffered as a boy when I was raped every night by my father. And we've got to acknowledge the impact that sexual offending has on the lives of New Zealanders. So, Mr. Speaker, the Bill of Rights, this bill does conflict with the Bill of Rights, and I just would like to read some parts of that. Read some parts of the commentary from the bill. Extended supervision orders are designed to protect the community from high-risk offenders, not to punish offenders for past offences. However, the Parole Act 2002 treats extended supervision orders as a criminal justice process. Therefore, an extended supervision order could be interpreted as a form of penalty and thus in breach of the protection against double jeopardy. And we spoke about this in the previous bill, Mr. Chair, that we don't want people to be punished for the same offence, but we also must look at, and there is tension between the rights of people but also public protection. And for me, knowing now what I know about sexual abuse and violent offending, Mr. Chair, I would like to swipe, Mr. Chair.
Kelvin Davis.
Err on the side of protecting the rights of public, Mr. Chair, even if that does upset other people. Sorry, Mr. Chair, I'll just find the relevant part. I just want to draw the attention to clause 7.2, and it says an offender may be an eligible offender, to avoid doubt and to confirm the retrospective application of this provision despite any enactment or rule of law. An offender may be an eligible offender even if he or she committed a relevant offence, was most recently convicted, or became subject to release conditions or an extended supervision order before this part in any amendments came into force. So this isn't just looking at people who have offended after the commencement of this Act, but those who are already in prison now, making sure that when they are released in the next few months, as they start being released, the first people who came under the extended supervision orders, that they are included under this bill, Mr. Chair. Mr. Chair, I also just want to raise a local situation up north there for somebody, because we are talking about people who we don't think will ever be recidivised. That we think that there is an imminent risk of them reoffending, and up north we had the instance of James Parker, the deputy principal of a school up there, and we, in my opinion, although he got preventative detention, and I'm grateful for that, Mr. Chair, he could well have been given a finite sentence and at some stage in the future be released. This is a guy symptomatic and an example of the sort of people that I just do not think he will be recidivised. This guy was cunning, manipulative. He took advantage of people. He really worked the system and played with people's minds so that he was able to offend at will. In fact, so bad was his state of mind, in my belief, that when an accusation was made against him, Mr. Chair, and the charges were dropped, his offending actually increased and got more intensive and more bizarre. And this is an example of somebody, and again I reiterate, he did get preventative detention, that if he wasn't on preventative detention, I believe he'd be a perfect case of somebody that must come under these extended supervision orders for the rest of his life, because I believe that any young person, any young boy, such as the same age as the boys that were in his charge, would forever be in jeopardy if they were around James Parker, if he was ever to be released into the public, Mr. Chair. So I support this bill. I've seen the effect, the damage that sexual abuse and violent offending does. I've got no doubt that Mike Sabin across the way there, also from up north, as a former police officer, would have seen it in even more graphic detail and the effects than I saw. I mean, I just saw as a principal the effects on the kids in school and the difficulties that a lot of children had in learning. Just a final point, Mr. Chair, is that one thing we've got to forget, or not forget, is one thing we've got to realise is that offenders aren't necessarily the stranger guy, the weird-looking guy walking down the street. Too many people tonight, too many young people, too many people tonight will be abused by somebody they know, they love, and they should be able to trust. In other words, members of their family. And I don't think that we identify and out these people enough. And I believe by the nature of their offending, and it's often fathers offend against daughters and granddaughters and nieces, that these are people too that are will constantly recidivise. It's almost like they feel that it's their right to actually behave like this, Mr. Chair. And I would be remiss if I didn't raise these sorts of issues at the House. Kia ora.
I call Reno Tarakatni.
Tēnā koe, Mr. Chair. I'm pleased to